Hello and welcome to the YouTube channel of Themis Law Chambers. My name is Advocate Ashish Bali and I am here to talk about Negotiable Instruments Act 1881 along with some important judgments up till October 2019. Negotiable Instruments Act 1881 deals with negotiable instruments such as promissory notes, bills of exchange, checks, etc. Chapter 17 containing sections 138 to 142 was introduced with the object to instill confidence in the competence of banking activities and make negotiable instruments employed in business transactions reliable. In simple words, if a person issues a check as a mode of deferred payment and the payee accepts the same with the belief that he will get his payment on due date, then he should not suffer on account of non-payment. Section 138 Negotiable Instrument Act applies on dishonor of check for insufficiency, etc. of funds in the account of the issuing person who has issued the check for the discharge in whole or in part of any debt or other liability. Such person shall be deemed to have committed an offence and shall, without prejudice to any other provisions of this Act, be punished with imprisonment which may be extended up to 2 years, or fine which may extend up to twice the amount of the check, or with both. Now, nothing contained in this section shall apply unless the check has been presented to the bank within 6 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. It is pertinent to mention here that the check these days are valid up till 3 months from the date which is mentioned on the check. The payee or the holder in due course of the check needs to make a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of receipt of information from the bank that the check has returned unpaid and that the drawer of such check fails to make payment of the said amount of money to the payee or to the holder in due course of the check within 15 days of the receipt of said notice. On 17th October 2017, Delhi High Court in Dayavati versus Yogesh Gosai held that the criminal compoundable case of check bounce under Section 138 of Negotiable Instruments Act can be referred and resolved through mediation. This could actually help in speedy disposal of cases. The Honorable Delhi High Court also observed that the offence under Section 138 of this Act is primarily a civil wrong which has been given criminal implication. Negotiable Instruments Act was amended in the year 2018, and the Amended Act that came into effect on 1st September 2018 permits the court trying offence related to check bounce to direct the drawer to pay interim compensation not exceeding 20% of the check amount to the complainant within 60 days of the trial court's order to pay such compensation. This interim compensation may be paid either in summary trial or summons case where the drawer pleads not guilty to the accusation in the complaint or upon framing of the charge in any other case. This amended act also empowers the appellate court hearing appeals against conviction under Section 138 to direct the appellant to deposit a minimum 20% of the fine or compensation awarded in addition to the interim compensation. Here I would like to talk about some recent judgments on Section 138 of the Negotiable Instruments Act. On 19 September 2019, in the case of M. Abbas Haji versus T. N. Channakeshava, Supreme Court observed that the legal heirs in the case of death of the accused are neither liable to pay fine or to undergo imprisonment. However, they have a right to challenge the conviction of the predecessor only for the purpose that he was not guilty of any offence. On 17th October 2019, in case of Dr. Lakshman versus State of Karnataka, the Supreme Court has observed that mere filing of suit for recovery of money and complaint under Section 138 of Negotiable Instrument Act is not a ground to quash cheating case against the accused. On the same day, in case of Uttam Ram versus Devinder Singh Hoodan, the Supreme Court observed that the complainant need not prove the amount due in check bouncing case as if he is to prove a debt before civil court. Over the years, the trust and security of checks in financial matters has crumbled despite the judiciary taking several steps to expedite the recovery of money. If you're also facing problems regarding dishonor of checks, you may write to ashish@themislawchambers.com and I will get back to you as soon as I can. Please don't forget to like and subscribe our channel for informative videos on Indian law and press the bell icon to get notified whenever we upload a new video. Thank you for watching.